issue about the types of documents you will see sometimes when you are considering a business relationship, meaning you have not yet actually entered into a contract, but you're exploring your options in terms of whether there is a business interest and how to move forward with the parties. The issue that comes up is many times this evaluation process requires an exchange of confidential information. So the parties want to make sure that when they exchange the confidential information, that it remains confidential, and that when the evaluation of each other has concluded, and specifically if they decide not to go forward with a business arrangement, that the confidential information will be destroyed and or returned back to the original provider. So this document is an attempt to do that, and this is not to say this is the document that should be used, and we're not offering any legal advice or suggesting you use this document. This document is here for discussion and evaluation purposes, similar to the other two documents in the other video where we looked at the so-called full corporate offer and the letter of intent. So this non-disclosure, non-circumvent agreement sometimes is referred to as Ncnd, the abbreviation Ncnd, NDCA. I mean, lots of little different names for this. Sometimes just called non-disclosure agreement, NDA. And it's the first thing that comes out when two companies are considering discussion. So these are very common. It typically will go, well, we should talk about this. I think we've got something we should explore. Okay, well, good. We'll have my legal department get a NCND to you, and we'll get that signed next week, and then we'll sit down and talk about this. That sounds great. Okay, let's do that. So this is the kind of document, something like this, this type would normally be floated around for signature by all the parties. So just to take a look at some of the language in here, again, this is a NCND dealing with a potential oil deal in Russian oil, REPCO, Russian export blend crude oil, and there are three parties involved, ABC, so all the actual names of the party have been removed. And you'll notice right here at the beginning, the type of legal entity is different. So a corporation, which would be a U.S. LLC, which could be anything, could be probably a U.S. company here, and an SRL would be a foreign corporate entity, but collectively referred to as the parties and individually as the party. So typically in many agreements and even contracts, you will see some language up front, and sometimes the language is preceded by the word whereas, and it's designed really to kind of set the stage for the document. In other words, why are the parties entering into this document? And it precedes the normal substantive provisions of the contract. And sometimes there's discussion whether there's any actual legal impact, any legal significance to this language. But it certainly can be argued that by having language like this, it sets the context for the agreement, as well as the giving some idea of the intent of the parties as to what this document is to do. So I think it certainly gives argument to those who feel they want to use it to interpret the agreement. So again, this is a confidentiality agreement. So the first thing we have in this agreement is, as in many documents, you have a definitional section, and here the definition is relates to confidential information and the obligation to keep it confidential. So here, if you look at this definition, it's extremely broad, and parties agree information disclosed orally or in writing or made available by the other party to another party, including but not limited to, and then they list all the possible types of confidential information. So, obviously what is in this definition will differ based on the nature of the transaction, or it could be different. This is intended to be fairly all-encompassing, but you want to make sure that if there's anything specific to your business discussions where information will be exchanged or data or whatever, that is included in this list of information. And you see trade secrets, strategic plans, invention plans, customer information, banking and financial information, etc. And all other material, whether written or oral, tangible or intangible, shall be deemed confidential information. Now the problem is, if you are receiving confidential information, you want to know that what you have received is confidential. In other words, you don't want to have people talking and exchanging information, and then 3 months later they tell you, oh, by the way, that chart we gave you 3 months ago is confidential, and you didn't know that. So you want to make sure there's a provision in here that says that they tell you it's confidential. And in a clause like this, the parties agree confidential information disclosed prior to the execution agreement was intended to be and shall be subject. So this is retroactive. And the question is, well, what is that? I mean, when the guy said, hello, I'm a sales rep or the VP for XYZ, is that confidential? I mean, it could pose problems, and I think normally you want each party to have an obligation to tell you the information they are giving you is confidential, so you want it to be marked, normally have identified and marked as confidential, so there's no question about it. So this is, they're going to maintain the confidentiality of the information for a period of 2 years from the date of disclosure. So arguably that means, if this agreement runs, let's say, 3 years, and you get confidential information on the very last day of the effective date of this agreement, it's still covered for 2 years from that date of disclosure. In other words, the obligations continue beyond arguably the term of this this contract, and 2 years is not unreasonable. I've seen 1 year, I've seen 2 years. Some people want 5 years. I think if you're beyond 5 years, if you're in a 10-year period of frame of time, you're getting pretty excessive. But some people demand it. Obligations. Recipient obligations. The parties expressly agree the recipient shall not use confidential information in the development of any products or services for its own account or for the account of any third party expressly agreed to, unless expressly agreed to in writing. So if you want to use it somewhere else, you got to get our permission. Furthermore, the parties agree not to use the confidential information for purposes other than that necessary to consider the possibility for this business relationship. So it's not only that you won't use it there, but you will affirmatively only use it for this set of discussions. How much care do they have to exercise in protecting your confidential information? Recipients shall protect the confidential information by using the same degree of care, but no less than reasonable care. So here's the test: no less than reasonable care. To prevent the unauthorized use and dissemination of the information. So what that means is, whatever standard of care you use to protect your own information, you have to use to protect our information. And by the way, if you happen to be sloppy, there is a floor on that, and the floor is no less than reasonable care. Recipient shall limit its internal disclosure of the confident to only those employees and agents who have a need to know. So here's a standard. Do they have a need to know the information? In other words, you now have an affirmative obligation to limit access to that information. And the standard for dissemination is need to know. Okay, let's take a look at exceptions. So those are the duties and obligations on the party, but what are the exceptions? Well, the agreement shall impose no obligations with respect to confidential information, and then here we have 6 exceptions. And let's take a look at those. The first one, well, if the information that is confidential becomes generally known or available to the public, then you don't have to protect it anymore. So for example, if this involves the secret formula for Coca-Cola, and you get that secret formula, but then it becomes available to the public, then you don't have an obligation to keep it secret anymore. Was acquired by the receiving party before receiving such information from and without restriction. So that means if you knew it before we gave it to you, and you didn't have a restriction on it, then you don't have to keep it confidential. Is rightfully furnished to the receiving party by a third party without restriction, unless furnished to circumvent this agreement. So if somebody, a third party gives it to you and there's no restriction on it, and this isn't designed to circumvent this agreement, then you're allowed to disclose it. Information the party has independently developed. You develop the secret formula for Coca-Cola, or the secret spices for, Kentucky Fried Chicken or something like that, then, you do not have to keep it secret unless you developed it to circumvent the agreement. Is required to disclose pursuant to law, provided the receiving party uses reasonable efforts to give the disclosing party reasonable notice of such required disclosure. So what is this? Well, you're in a lawsuit, maybe an antitrust lawsuit or criminal prosecution, and you get a court order, receive a court order demanding that you turn over certain confidential information subject to this provision. Well, this exception means that you obviously don't want to be in violation of the court order, so this allows you to give the court that information, but first you have to give the court that information, give the other party information that you are going to disclose it. And why is that? The reason is they will then file a motion before the court explaining why it's confidential information, and either ask that there be no compliance with that order, or ask that the court review the information in camera, in secret, and that the disclosure be limited only to parties in the lawsuit that need to see it. So it gives the other party an opportunity to argue its case before the information is disclosed to the court or whatever that body is. Could be an arbitration panel or whatever. And the last one is disclosed with the prior written consent. So meaning, hey, if we say you can disclose it, then you can disclose it. So, and so you can see right here, this last sentence, prior notice to such disclosure in order to afford them reasonable opportunity to file objections. So you can see that's what's going on with the legal aspect. Continued development efforts. They have been engaged in, and the parties have been engaged in and continue to engage in activities to develop this deal and other deals, but they acknowledge that nothing in this agreement prevents them from talking to other parties. Meaning the fact we're talking to you and sign this agreement doesn't mean we cannot explore a business relationship with other parties. Ownership of the confidential information. By signing this agreement, we are not relinquishing our ownership rights. We're not giving you any license or other rights to the confidential information. So we continue to own it. At the end of this period, you have to give all that confidential information back to us. And give it back to us, and return it, or destruction. So either give it back to us or destroy it. Now, the issue here with today's world, where everything tends to be digital and emails and everything's stored on flash drives and laptops and the cloud, what's needed here is some kind of a statement, preferably under oath, that says the party has made good faith efforts to return and or destroy all versions of the confidential information, including electronic versions, that it has made a good faith effort to destroy the electronic versions of the information. Non-circumvention. So this is the non-circumvention part of the agreement, and it says that the parties agree not to circumvent each other. In the process of negotiation, they may introduce each other to companies they're selling, purchasing similar activities or goods or whatever, and the party retains ownership of such referral, and that the other party cannot deal directly with that party. So don't go around us. And the circumvention is for a reasonable period of time, 2 years. And anything that gets longer than 2 years, if you get up into the 5-year range or more, courts will look at that and begin to say, no, that is an unreasonable business restraint on that party, and they may strike that clause or revise that clause to a more reasonable period of time. Non-solicitation for a period of 2 years after the termination of this agreement, all parties agree they will not solicit for hire the other people. In other words, sometimes in the course of negotiations, you meet somebody on the other company, say, man, that guy is really great, or man, that woman really knows her stuff. We should try to get her on our team. So here is a restriction. You can't hire or try to hire our people. Let's see, what else do we have here? Remedy, let's see, expiration. So this one is good for 2 years from the last date of execution. So the last party to sign the agreement, that date starts the 2 years. And that's reasonable. And if you go to 5 years, I mean, I've seen them 5 years. Some people push for 10 years. I think 2 is very reasonable. 5, you do see 5 years. I think you're starting to reach a limit when you get that long. So these are what we're going to call the boilerplate provisions. If you look at these, you'll see they're pretty straightforward. They're independent contractors. This is the entire agreement. It's nothing oral agreements. They're not going to modify this. You can only modify this in writing, written consent of all the parties. If one part of the agreement is illegal or valid, it doesn't mean the entire document is illegal, just that provision. This constitutes the product of negotiations. So sometimes if one person had the power of drafting the document, that document will be construed against them if an ambiguity arrives. So this is but this is a product of negotiations and not any one party. You certainly understand this paragraph. Each party represents and warrants it has authority to sign the agreement, knows it has actual authority, and has taken all steps prior to signature to obtain that authority. So if you had to get a board of resolution, resolution for the board of directors, you got it. Disputes will be resolved in arbitration in the District of Columbia, and you can go to a court of competent jurisdiction to enforce the arbitration decision. And what is the applicable law? Well, here the parties chose Unidroit, which is not a body of law. It is a body of principles as to how international contracts should work. It does not require any ratification by the country like the Convention on International Sale of Goods, CISC. This is, it's like the Incoterms. It's like if you want it to apply, you just say it applies, and then it applies. And here you see the signature block where the companies are signing it, not the individuals. The companies are signing the document, and then by indicates who the agent is for that company. Oh, and here, see, this one company was from Romania. I guess SRR would be the Romanian company. So that's it. I guess a 3-page document. Again, I would say these kinds of NDAs or NCNDs are very common. Big companies are signing these all the time whenever they're exploring, business relationships. And if you do any business, domestic or international, you most likely will see something like this. So.